And I'm going to turn it over to, I guess, Bob.
Okay, fair enough. Thank you, Anne. Thank you for being here today. It's a bit of an unusual topic, ethics at mediation and kind of the things that come up with that. Even though we have an hour and a half, which is a long time, there's more material than we can really cover in an hour and a half. So we'll just go an hour and a half and see where that ends up. If you have questions during this presentation, which I suspect there very well may be a number of them, please use the Q&A feature. And I'm going to monitor the Q&A feature. And what you're going to discover pretty quickly is that Mary Grace is a wealth of information about the ethic challenges that we all face as practicing attorneys and mediators. By way of introduction, I'm going to share my screen at this point. And we have the presentation here. You should be seeing the presentation on your screen. And if you have questions or interest about our background, Mary Grace's background is here. It's a little bit more detailed than what Anne was providing. I've got mine on the second page. And Mary Grace put together a list of resources that are good places to find ethics kind of information outside of this program as you're looking for guidance. Just a note, an observation as we begin. What happens is, and we all have the opportunity to do this as practicing attorneys and as mediators. We see other people's work, and we know that a lot of times when you have a second set of eyes on a problem or a project, a lot of times you bring an additional perspective to that. And as attorneys and as mediators, sometimes we see errors or problems in cases that we run up against. Sometimes those problems are the way that the case has been put together, and there can be ethical issues involved in some of the ways that the case comes into mediation. So this program specifically is focused on what kinds of things do we typically see at mediation, or what can be a problem at mediation. Those are dovetailed with the ethics opinions that are found on the State Bar website. So the context of today's program is a series of hypotheticals, and a lot of the hypotheticals are taken straight out of the State Bar ethics opinions, because those opinions also use hypothetical examples. And then some of them are just generic put together hypotheticals that then relate to resources either from the ethics opinions or other ethics sources. And Mary Grace will talk more about that as we go on.
And I just want
to
just quickly apologize. One is I encourage everybody to take a moment and go to the CRPC website at the State Bar. The reason is that I cannot tell you how often I get individuals calling me and they're quoting the old rules. So they're quoting the, rule 100 dash, whatever. And that isn't our numbering system any longer. The new numbering system is in line with the model rules, and some of the language has changed. So if you aren't familiar with the new rules, I do encourage you to review them. They were released and published and adopted in November of 2018, but unfortunately there are a lot of attorneys who haven't caught up to speed with the new rules.
Thank you, Mary Grace. So here is our first hypothetical. Well, this is the background. This is the kind of the explanation of the sources of these, which is what I just summarized just a moment ago. Here's our first hypothetical. And I'm just going to read this, so we'll go through it together and then do our discussion afterwards. So here's the factual background. Carrie client was involved in an automobile accident and sustained significant personal injuries. She consulted Larry Lawyer, who agreed to represent her on a contingency basis, which provided that Larry would receive 33% of any recovery prior to filing suit, 40% of any recovery thereafter, and 55% of any settlement reached 30 days prior to the first scheduled trial date or thereafter. 2 months before trial, Larry proposed mediation, and the defense agreed. The defense proposed 2 mediation dates, more than 30 days prior to trial and 2 dates less than 30 days prior to trial. Larry, Carrie, and the proposed mediator are all available on each of those days. All depositions in the case have been taken, including all expert depositions. All of the case workup has been done. Pursuant to his engagement letter and fee agreement, Larry's fee will be 40% if settlement is reached at mediation, which is scheduled more than 30 days before trial, but it'll be 55% if settlement is reached at a mediation scheduled less than 30 days before trial. So this highlights the issue about timing of the mediation with respect to the compensation of the attorney. Here's the questions. The first question: can Larry ethically choose a mediation date that's less than 30 days before trial because doing so will entitle him to receive a larger percentage fee if the mediation is successful? Why or why not? So it's a question about timing. So Mary Grace, I'm going to invite you to address that.
Yeah, so the first thing that I think, you need to think about is with regard to our business professions code, which is 6128B, which is an attorney is guilty of a misdemeanor when they willfully delay a client's suit with view of his own gain or her own gain. So if this were to be done when an attorney is seeing dollar signs for themselves, then it's definitely unethical. The other thing to think about is Rule 1.7b, which is the new conflicts rules, and it's where an attorney has a conflict with their client. The difficulty with this is that, yes, it allows an attorney to waive a conflict, but there are certain types of conflicts where the attorney, it's considered an unwaivable conflict, even if the conflict waiver existed prior to this representation. The reason is that what we're looking at here is that the client has an interest and the attorney has an interest, and the attorney's interest to receive a bigger portion of the contingency fee would be in direct conflict with the client's interest in terms of what they would be walking away with. So if you're looking at those two issues alone, it may actually be that if Larry's pure goal was to obtain that additional 15%, then it is absolutely a conflict, and it probably is a conflict that would require Larry to walk away from the representation, or which would be even more ethical, which would be to continue the representation, but only accept the 40% as opposed to the 55%.
So thank you, Mary Grace. And if there's questions as this program moves forward, if you have questions, just enter them in the Q&A, and we'll monitor the Q&A, and I'm sure there will be questions, and then we'll work them into the program. So here's the follow-up on this scenario, and what you're going to see is these hypotheticals. It's like the old LSAT test. You take one set of facts, then you keep stacking on different variables, and that's the structure of the same program here today. Question: even if a good reason exists for Larry to delay the mediation date, would his fee of 55% potentially run afoul of his ethical obligations under the rules of professional conduct? And that's just because it's a 55% fee. So invite your comment, Mary Grace.
Yeah, so in this particular situation, let's just assume that Larry has no nefarious goals as a result, that the delay didn't happen because he, was thinking, dastardly deeds and was intentionally delaying. Instead, this was a mediation. Let's just assume that it was the defendant that had called for the mediation and everyone agreed and it was within this time period. Then what you're really going to be looking at is whether or not the fee itself is conscionable. Rule 1.5a prohibits a lawyer from obtaining an unconscionable or an illegal fee. This concept of unconscionable or illegal fee really is a term of art, and I think we want to go over to the next slide, which gets into a bit more how you evaluate what an unconscionable fee is. It is a fact-intensive determination. So in this particular situation, you're looking at all the facts and circumstances. So in this, if there was the delay as a result of the defendant last minute decides to call for the mediation, then one, we're going to look at that. Then they're also going to look at, like we discussed previously, whether or not the lawyer engaged in some sort of fraud or overreaching. Maybe the lawyer was delaying the mediation. And so let's assume that maybe that didn't happen. Then you're also going to look a bit more at the value of the services. And what the value of the services means is they're looking, the courts and case law has always looked at the attorney themselves. So the lawyer's level of experience, effort, whether or not in terms of region, it makes sense that the lawyer would receive 55% of the total fee, which means that the client receives less money than the attorney. So it's more of a fact-intensive evaluation than just, this concept of unconscionable fee. There's several factors involved that would be considered when you're determining this fee is unconscionable or not.
Thanks, Mary Grace. So this is not a pre-planned question. This is off the cuff. So Mary Grace, where are you likely to see, or how are you likely to see these kinds of issues come up with respect to whether or not a lawyer has charged an unconscionable or an overreaching fee?
Most often is after the mediation or after the litigation has happened, or the representation has happened, and the client has signed the settlement agreement and funds are about to be dispersed, and the client realizes, oh my gosh, let's just assume that it's keep numbers nice and clean. There's $100,000 and the client was expecting, 70,000, and they thought the attorney was gonna get 30,000, and they didn't really understand the fine print. And then they realized, oh my gosh, I'm only getting the 45,000 and my attorney's getting the 55,000. In that circumstance, when the client, says, hey, I don't agree with your fees, then you have a fee dispute. Then you're looking at the conscionability of the fees themselves.
If a lawyer finds themselves in that kind of a situation, what's really the best practices for the lawyer to follow in addressing that?
There's a couple of approaches that you can do. First one is to figure out where the client lies in terms of what they're upset about. If the money is, let's just assume that the money was dispersed in a $100,000 check. It goes into the IOLTA account. The client is disputing, they agree that at the very least, let's just assume that the client agrees that the attorney should get 40,000 and they should get 60,000. So that means that there's $100,000 or $10,000 that's in dispute. It is reasonable, and let's just assume that the client literally says, I feel I should get 50 and you should get 40. At that point, it is perfectly acceptable for the attorney to disperse what the client wanted, which is pay themselves their percentage, which the client agreed to, which is, the 40%, and pay the client their difference. And then whatever is actually in dispute, keep it in trust. You don't want to ever move it out of trust. You keep that in trust. Other ways that this can happen is that the client doesn't actually say that they aren't happy, but they kind of hint at it. At that point, what you want to do is remind the client that hopefully you have in your engagement letter some sort of clause that reminds them about how you handle fee disputes. You say to the client, it looks like we have a fee dispute. It is up to you to file with, whether it's the state bar, each JAMS, whoever, depending on what your engagement letter says, and you let them know that they have this opportunity. Again, you can disperse based on how the client so far agrees and keep whatever is in question in the IOLTA account. Another option is to find out where they lie. And, no one really wants to get into a fee dispute. I know that we don't, as lawyers, like to give up what we feel we've earned. But sometimes the cleanest thing is to find out what it is that they want. And if you maybe you can negotiate something where the attorney you get relatively close to what you feel you are owed, and the client gets what they feel that they are owed. So, and I'm also generally a big fan, if you're squabbling over, let's just say $2,000, I'm a huge fan of just giving the client what they want. Because if the client feels that they somehow were taken advantage of, it's not just the fee dispute that's the problem. They're going to complain to the state bar. And unfortunately for lawyers, when the state bar learns that there's money involved and the client feels that the money was somehow, they were taken advantage of, there was unconscionable fees, that's when the state bar's ears perk up and they take a complaint a lot more seriously. And so you want to avoid the state bar complaint. And I cannot stress that if your client says, hey, if you don't give me my money, I'm going to go to the state bar, do not negotiate when you settle this. Do not include that they can't go to the state bar. That is absolutely unethical. You cannot ever preclude a client or a former anyone from going to the state bar as a part of your final settlement.
Good. Thanks, Mary Grace. Okay, here's the next hypothetical. Same facts as previous hypothetical, but with the following additional facts. Prior to mediation, Larry Lawyer met with his client and discussed the mediation process. Larry told Carrie that everything said at mediation is confidential, so that nothing could be later used in any kind of non-criminal legal proceeding. Larry said this included not only communications between plaintiff and the defense, but also prevents any discussions between Larry and Carrie from later being used, even if there were later some kind of disagreement between them. However, Larry did not provide Carrie any kind of written disclosure, and he did not get Carrie's signature on any written disclosure to this effect. So the question, has Larry committed some sort of violation by failing to provide Carrie with a written disclosure about mediation confidentiality? And I'm going to put up the source here, which is evidence code 1129. So do you have any comments on that, Mary Grace?
And as you recall, Bob, when we first wrote this curriculum, we talked at length about this particular evidence code. And as of today, I'm still not familiar with any state bar discipline that is a direct result for failure to comply with this evidence code. It doesn't mean that it's not in the works. It just literally means that at this point, we don't know where the state bar lies in terms of this issue. But the failure to comply, let's just assume that there is a state bar complaint. State bar decides it among all of the other issues in the representation. This was one of many. So what they're going to look at are several rules of professional responsibility. And the first one is going to be Rule 1.1a, which is your duty of competency. And it says that that a lawyer shall not, and the additional part that we kind of left out was with gross negligence, repeatedly fail to perform services with competence. Gross negligence is actually a standard within state bar land. We apply that. But they look at the totality of the representation. So that's one piece. Another piece, which we didn't add, is also Rule 1.3a, which is your duty of due diligence. The difference between those two rules is one has to deal with legal services. So that means the totality of what an attorney does. The other piece is due diligence, which is really looking at the representation itself. So if Larry had failed to obtain the disclosure as it relates to this representation, I would say that both Rule 1.1a and Rule 1.3a are impacted, and there's an issue there. Finally, there's this additional rule, which is Rule 1.4a3, which is our duty to communicate to clients. And it says that a lawyer must keep a client reasonably informed about significant developments. And this is a significant development. And so in this particular situation, a lawyer, notice the word shall. So that means they absolutely have to do it. There isn't that wobbliness. If Larry realized he failed to do it and did it, say, he got the signature and disclosure, say, a month into the mediation. Well, he did it. Does it meet the reasonableness standards? Maybe, maybe not. 2 weeks afterwards, I think that probably falls within reasonable, because I think sometimes we lawyers, we thought we handed everything over to the client and maybe we didn't. So though you absolutely have to communicate within that, the reasonableness has to do with the timing of it. Does that make sense, Bob?
Well, I think I'll interject a minute here, if I may. So if people attending this program today don't have the evidence code right at your fingertips, and you're not familiar with the evidence code 1129, this was a statute adopted some time ago, and it's a completely new provision, and it's really the outgrowth of the Cassell case. So what happened in Cassell is there was a mediation, and the attorneys, you can see it in the court opinion, they really put the squeeze on the client. They pushed him hard for settlement. It said they kept him there really late. They sort of sidetracked his efforts to try and get something to eat. I mean, and then they wouldn't really answer his questions directly, and they're really putting the squeeze on this client to settle. And after the client settles, they're, of course, have buyer's remorse or seller's remorse or settler's remorse, whatever you call it, and they're regretting the fact of the settlement, and so they want to bring in what happened in the mediation and what the attorneys did. And because of this very, very strong confidentiality involved with mediation, the client could not do it. But this 1129 is the outgrowth of that Cassell case, because afterwards the legislature took this up, and there was a lot of discussion about whether or not mediation confidentiality should be compromised in some circumstances, including attorney misconduct. And this 1129 was it was a compromise arrangement that said, okay, we're going to keep mediation confidentiality inviolate except for criminal actions and those types of things. But what we're going to do is force the attorneys to disclose to the client up front that nothing that happens at mediation is going to be admissible afterwards if there's a disagreement between the attorney and the client. And that's the outgrowth. That's this 1129. And there's very strict requirements about the disclosure. It has to be almost verbatim. There's a first part of it's verbatim, and then you have to make these other representations. It's very, very strict. So that is supposed to go out in advance of every civil case mediation. And so that's the basis of this. Anything further, Mary Grace, before I go?
And I agree with you on that. And obviously for best practices, it would be pretty straightforward and easy to cut and paste what is in the statute and create that as your own document. That is acceptable, at least from a state bar perspective. If you're trying to figure out, how do I create this? It's in the statute, just cut and paste and use it. Again, with regard to communications, yes, you absolutely have to do this. Yes, the rule is very strict in terms of requirements, but I do think in terms of like state bar land and discipline purposes, like absolutely failing to do so is a problem, but doing so, but maybe you didn't do it either beforehand, but you did it a week or two late. I think that's again, it's a reasonableness standard. I think it's reasonable to have made that mistake. I mean, I feel like I could definitely defend it before the state bar. But you definitely have to do it. That's, clear as can be.
Okay, let's go on to the next hypothetical. Thanks, Mary Grace.
Mm-hmm.
Same facts as previous hypothetical, but with the following additional facts. In the mediation brief submitted on Carrie's behalf, Larry asserts that he will have no difficulty proving the defendant was texting while driving immediately prior to the accident. In that brief, Larry references the existence of an eyewitness to the account, asserts that the eyewitness's account is undisputed, asserts that the eyewitness specifically saw defendant texting while driving, immediately prior to the accident and asserts that the eyewitness's credibility is excellent. In fact, Larry has been unable to locate any eyewitness to the accident. So this is based on one of the State Bar ethics opinions on the State Bar website. Here's a question. Is Larry's fictitious representations about the existence of a key eyewitness mere puffery such that it is ethically permissible? So I'll invite your comment, Mary Grace.
Absolutely. So the key fact here, at least as it relates to the fact pattern, is Larry's knowledge. You cannot misrepresent facts that you have. You know, puffery really is sharing information that you might be exaggerating with the goal of obtaining a certain negotiation. Whereas in this particular fact pattern, we're talking about, I have, you know, a set of facts that's going to essentially blow everything out of the water. Therefore, you should negotiate with me and give me what I want. And it's clear that he exhausted his resources and then still made this statement. And so in that sense, it's not considered puffery. It's actually a misrepresentation of the access to facts that he has. It would be different if he had not exhausted his resources and instead, you know, shared information that he believed this existed. Because, you know, in that sense, absolutely, an attorney should employ, you know, all of their resources to to advocate for their client in the best possible way. Can you share the authority of Rule 6068D?
Yes.
So this is the authority, and it allows for, you know, the attorney to employ skills in order to obtain a certain goal, but they can't do it in a way that would mislead a judge or judicial officer. And the additional rule that I would like to point you all to is Rule 3.3, which is an attorney's duty of candor and honesty to a tribunal. And if you then, and this kind of, again, these are the new rules. So if you, almost like a giant puzzle sometimes, Rule 1.0.1. So it's this is the rules and definitions, and subsection M defines tribunal, and tribunal includes, and I'm going to read it for you because I was just reading it to Bob really quickly. It says a court, an arbitrator, an administrative law judge, or an administrative body acting in an adjudicative, tough word, capacity, and authorized to make a decision that can be binding on the parties. So even though this is mediation, to employ misrepresentation in this type of environment is actually absolutely unethical under Rule 3.3. And so, and when you're doing this, it actually is it would be considered moral turpitude, because you're being, you know, dishonest, essentially. I think the word, I find this rule interesting because it includes the word misdemeanor, which is, as we know, is a crime. But it is serious. The State Bar takes this quite seriously when an attorney is presenting information that truly has no basis. I've seen this often enough, and, you know, judges can refer, and, you know, I don't know about mediators much, but I definitely know that judges definitely refer lawyers up when right. So David Meadows says, I don't understand how a mediator who cannot decide anything is a judicial officer. The way that and I'm going to cut and paste this so you all can see it. The way Rule 1. And I'm going to share it in text just so you know. Here is the language for the definition of a tribunal. If you look at the reading, it would really be dependent on whether this mediation is going to be essentially binding. And that's where the problem would lie if you're utilizing this type of false false, what's the word I'm looking for? Just misrepresentation. If it is an unbinding, I mean, I think that makes things obviously very different, but in this language for tribunal, it's pretty clear that it says, or an administrative body acting in an adjudicative position and authorized to make a decision that can be binding on both parties. So I think that really would be where the problem would lie.
Interesting question. Yeah, I think it's pretty clear that that no mediator has the ability to adjudicate things. So you would definitely have that issue with that language.
You would have that issue. I mean, I do think it's very dangerous though, as a lawyer, even in a mediator environment, to to misrepresent information.
Well, you have these other issues, and this because of the Cassell case and the high confidentiality that's associated with mediation, there might be statements made at mediation that are not going to come in some kind of later disciplinary proceeding. But this one specifically says here that every attorney is guilty of a misdemeanor who does these kinds of things. And one of the exceptions for mediation confidentiality is criminal activity or criminal action.
Right.
And so it's a substantial risk to think that because I'm mediating that I can avoid having any of this come out later on if it rises to that level. So it's a real prevalent point. Yeah.
Under rule, I'm just pulling up Business Code Profession 6068, where there is a duty. We have an absolute duty of honesty and candor, period. So if you're hedging your bets on the fact that you don't believe this is a tribunal and these rules don't apply, fine. But even then, we still have this broader duty of honest and candor to each other, and we have a duty of civility to each other. So misrepresentation doesn't really fall in line with our broader duties, period. And I think that's where it also gets extremely problematic.
So here's the next slide on this. Attorneys' misrepresentations about the existence of a favorable eyewitness and the substance of the testimony before the attorney purportedly expects the witness to give are improper false statements of fact intended to mislead defendant and his lawyer. Attorneys making the misrepresentations regarding the existence of favorable evidence for the purpose of having defendant rely on them. Attorney has no factual basis for the statements made. Further, attorney's misrepresentation is not an expression of opinion, but a material representation that a reasonable person would attach importance to in determining his choice of action in the transaction in question, and are thus misrepresentations regarding the existence of a favorable eyewitness, which constitute improper false statements and are not ethically permissible. We're going to talk further in this program about the difference in a little more detail between puffery and what that is and misrepresentation. But in this factual pattern, it seems pretty clear that that's a misrepresentation, not just puffing something up for effect purposes. So I'll go to the next slide here. And this language is taken from the ethics opinion.
And I encourage everyone to read that ethics opinion. It's very well written. Sometimes some of the ethics opinions, I think, are written more towards people like myself, but this particular ethics opinion is very well written, and I think it's extremely user friendly, which is nice to be able to see about ethics opinions.
We'll circulate these slides afterwards, so you'll have this opinion number, so you don't have to worry about capturing it in your notes. We'll have it after.
We'll also send the ethics opinion too, so then people can have access to it.
Okay. So here's a question. Is the applicable truthfulness standard relaxed at mediation because the parties and counsel are negotiating at arm's length? And here's the authority on that. The ABA cautions that a lower standard of lawyer truthfulness is not warranted because of the consensual nature of mediation, or because the parties somehow waive protection from lawyer misrepresentation by agreeing to engage in a process in which it is somehow understood that false statements will be made. On the other hand, the ABA has recognized that puffing or posturing may be permissible based on the generally understood norms of negotiation. The ABA defines puffing or posturing as statements upon which parties to a negotiation ordinarily would not be expected justifiably to rely. So that's how this opinion, this ethics opinion, handles puffing. So in other words, they're not seeing it quite this clearly, but if you're making statements about people are not justifiably going to rely on them or expected to, then you can do that kind of puffering or posturing. So the next slide talks about that some more. What kinds of incorrect, inaccurate, or incomplete statements qualify as puffery, such that their assertion does not rise to the level of dishonest representation? And here's the answer, and this is again from one of the ethics opinions. Under generally accepted conventions in negotiation, certain types of statements ordinarily are not taken as statements of material fact. Estimates of price or value placed on the subject of a transaction and a party's intentions as to an acceptable settlement of a claim are ordinarily in this category. If this were not the case, then in every negotiation or in every mediation, when somebody says, well, what will you take? And if you were bound by ethics sort of stringent ethics standards to say, well, my client will take X, negotiation would just go out the door. And so the way that the ethics rules handle this is they just say, well, people aren't justified in accepting that as a statement of fact about what your client will or will not take. And that's how the ethics opinion, the State Bar deals with this. Yeah.
And that's just, good lawyering. I think a good division is really having to do with when puffing is made for, the negotiation of what they're looking for in terms of the financial gain or, the ultimate settlement. But if it's something where it can be discoverable, like facts, and, the fact that an attorney may have exhausted their avenues in terms of collecting data and information to get to a certain financial settlement, that isn't the same as saying something like, and we'll get into the next sets of, my client is willing to settle for X, and that it's far above whatever the client is, maybe even sometimes even what you might think the real value of the case is.
Okay, so here's the statement from the ethics opinion. A statement of opinion is not actionable, nor is a statement of puffery. And a statement of puffery is one that is extremely unlikely to induce reliance. Ultimately, the difference between a statement of fact, such as the eyewitness, or mere puffery, such as what will your client take or what's your case worth, rests in the specificity or the generality of the claim. So here's the example. This is a reported case, Coviello versus State Bar, where counsel filled in the names of grantees in 2 deeds without authority to do so, and showed them to opposing counsel, thereby deceiving opposing counsel in order to gain a benefit for himself and his client. Disciplines of 6 months suspension imposed. So we have the next hypothetical. I'd like to take just a minute and revisit for just a moment 1129 before we go on to this next hypothetical. 1129, as you will recall, is the code section that requires the written disclosure. And just a further follow-up on this, we didn't talk about this yet. What it says is, this is a reading from 1129, except in the case of a class or representative action, an attorney representing a client participating in a mediation or a mediation consultation shall, as soon as reasonably possible, before the client agrees to participate in the mediation or the mediation consultation, provide that client with the printed disclosure. So the standard on timing is as soon as reasonably possible before the mediation or the consultation. So as we talked about, if somebody goes all the way through the mediation without giving that disclosure and then gives it after the fact, I suppose that's better than not giving it at all, but the sort of the barn door may have been left open and the animal's out of the barn at that point if the activity complained about or that the client has heartburn with was part of the mediation. Because what happens is if there's a State Bar complaint and the client says, you know what, I never got this disclosure, or I got it after the fact and I didn't realize what could happen in this mediation, and now I'm barred from doing this kind of stuff, that attorney is going to be in the unenviable position of having to explain why this client wasn't fully advised in advance about what was going to happen and then settle their case based on X, Y, and Z. It seems to me a very uncomfortable position to be in. And then they're calling Mary Grace and saying, please take us up and help me with this, but I didn't do it.
I would also say, though, that in those types of situations, at least my argument before the state bar would be going back to Rule 1.1, which is, it's a gross negligence standard, and Rule 1.3, which also is a gross negligence standard, that, because there is a case, and like I just relied upon it for a different client, that simple negligence is not a state bar, is not disciplinable before the state bar. Whereas gross negligence, which is, again, it's a higher standard. You're looking at repetition of the behavior. You're looking at the full representation. So let's just assume that the representation was actually pretty good and the client got kind of what they needed for the most part, but you failed to do this. And I would argue that this is not a state bar disciplinable matter, but is a malpractice issue. And there is a difference between the two. So you may not get disciplined for state bar purposes, but it doesn't mean that you're off scot-free. It may just mean, not just, but that it may actually mean that you committed malpractice, and that's the appropriate avenue for this type of failure to act.
Very helpful. I think for lots of practitioners who don't spend a whole lot of time in these state bar ethics opinions, or a whole lot of time in ethics land or state bar land, it's helpful to know that a simple act of negligence is not as disciplinary or a basis for discipline, as opposed to gross negligence. That's actually a very helpful point.
I think that's an important division. Yeah, it's really important, actually.
Very helpful now. Okay, here's the next hypothetical. While the mediator is talking privately with Larry and Carrie, he asks Larry and Carrie about Carrie's wage loss claim. Larry tells the mediator that Carrie was earning $75,000 per year, which is $25,000 more than Carrie was actually earning. Larry is aware that the mediator will convey this figure to the defendant, which he does. This is based on the state bar ethics opinion. So here's the question. Is Larry's fictitious representations about Carrie's wage loss mere puffery, such that it is ethically permissible in settlement negotiations? So what would be your comment on that, Mary Grace?
Absolutely. I mean, they definitely, and that's good lawyering, right? You want to, obviously you, if he were to say something super egregious, like, oh, it's $1 million, then that's probably not the best way to go. And that's just, I would say that's bad lawyering. But if it's reasonable, even though it is high, then, the defense should always assume that, even the defense's offer, you should always assume is nowhere near what they're what they are really willing to settle for. And in this case, I don't believe that there's no misrepresentation. He's simply keeping the facts to himself.
So, okay, well, okay, you heard it here. My own self, it gives me some pause if I'm thinking about a mediation and being in the attorney role and knowing that my client is actually something less and saying they're representing something more. Wow, it's an uncomfortable position for me, but I'm not in front of the state bar all the time, for which I'm grateful. So, I mean, Grace is, so I'll defer to her on this. Okay.
But is it the worst thing you can do? I mean, I'm not saying that I'm not saying that you should do it. I'm just saying that,
matter of degree.
It's a matter of degree.
Okay. All right. Let's go to the next hypothetical. While talking privately outside the presence of the mediator, Larry and Carrie discuss Carrie's bottom line settlement number. Carrie advises Larry that Carrie's bottom line settlement number is $175,000. When the mediator asked Larry for Carrie's demand, Larry said, Carrie needs $375,000 if you want to settle this case. Okay, so this is based on the ethics opinion. So here's the question. Is Larry's representation that a settlement figure of $375,000 will be required to settle the case is it ethically permissible when Carrie has specifically stated that she will settle for $175,000? Okay, what's your thought on that, Mary Grace?
Hold on, I'm just pulling up my, hold on one second. Sorry, okay, I just gonna need to catch up on my slides, that's all.
Sure.
Sorry, I apologize.
Not a problem.
Okay.
So the
So
question
in
is, it says it's he says he needed 375 and Carrie said she'll settle for 175. Is it ethically permissible to for him to say that when he knows she'll settle for 175 and she's communicated that to him? And this is a little bit of a repetition of what we've talked about so far.
Again, it really is, it goes back to the misrepresentation of fact, like, and then and the difficulty is that with puffery, part of it really is that she, you as an attorney have your own personal style. So we're talking about, on one hand, we're talking about personal style. Once you get to that person, beyond that personal style, then you're really looking at, okay, what is realistic? And then you're looking at, I totally lost my train of thought. I'm going to read the answer because I think that's going to start there. And I apologize. I totally missed my whole train of thought on where I was going. So it says, a party negotiating at arm's length should realistically expect that an adversary will not reveal the true negotiating goals or willingness to compromise. So that's what you should expect, okay? So that's where where the attorney's statement of what a plaintiff will need, the matter is allowable puffery rather than a misrepresentation of fact. So you really, that's the key concept here, is that you're balancing the concept of what is the misrepresentation versus what is the puffery. Puffery is always allowable. Again, do I always agree with that? No, I mean, I'm not always comfortable personally, even in negotiations, because that's not what I do for a living. I do a very different set of law. But I do think that it is, you as the attorney have to very much so determine, like, where is the misrepresentation of fact end and where does the puffery begin? You need to figure where that tension lies because of the, what sets of facts do you have before you? What do you know your client? What do you know about your client? I think, Malcolm, you're correct. Like, where does the attorney, what do they know about their client? There may be things that they know about their client that allows them to add some more money to this. It may also be that they know something about the facts. We're getting a very narrow description of factual information where it's not just about, does this settlement figure include, I don't know, pecuniary damages, not just, financial damages in terms of loss of income, for example. There's a lot of additional ways that lawyers can figure out what the value is when they make a demand versus what is, reasonable based on, like, sets of facts.
Okay.
And I think that's where the tension lies with puffery.
Okay.
Does that make sense?
It does. Let's take the next hypothetical. In response to Carrie's settlement demand, the defendant's lawyer informs the mediator that the defendant's insurance policy limit is $50,000. In fact, the defendant has a $500,000 insurance policy, a factor of 10x. So here's the question, and this is based on one of the state bar ethics opinions. Is the defense counsel's misstatement of the amount of the policy limits mere puffery such that it's ethically permissible?
And again, this goes to that misrepresentation. And so when the defendant lawyer gives an inaccurate representation of the policy limits, that's something that's discoverable. And that's something that's where the misrepresentation happens. And that would be improper. It would be different if it were, for example, it wasn't the policy limits, but instead there was, I don't know, they're unwilling to, the max that they're willing to go is the 50,000, but they don't link it to the policy limits.
Okay. All right.
Because the facts are different. Like removing the policy limits, then I'm not saying it's right. I'm just saying that when you say something that is directly linked to a piece of information that is discoverable, that is, a part of the negotiations, such as a policy limit, that's very different than saying, for example, they can only pay 50,000.
Well, it's neither a statement of opinion, nor
Mhm.
is it something that people would not reasonably be expected to rely on, which are kind of the two
Right,
standards.
exactly. So if you were to say the whole, because if you were to say, if you, Bob, were the defense attorney, and you said, well, my client only has a policy limit of $50,000, then it would assume that me as the plaintiff's attorney would be like, oh, wow, that's not much.
You're going to rely on
Where
it. Yeah.
Because I would be relying on that. Whereas if you were to then say to me, my client is only willing to settle for this, whatever number it is, if you don't include the policy limit, then maybe I wouldn't be relying on it, because I would be telling my client, and we haven't even discussed policy limits yet.
Well, and to say
It's two different.
To say what people are willing to settle for is in the example from the state bar ethics opinion, it's not the kind of statement that people are generally expected to rely on. And anybody with any sophisticated experience in negotiation knows that. You're not going to come out of the blocks with your best offer. I mean, everybody knows that, and it's understood. So it's not a problem to say those kinds of opinion or what's not shouldn't be relied on. As a policy limits is completely different. If that's in your sole control, it's a material fact.
And I would even say, like, going back to Carrie's living expense, even a much lower amount, but her living expenses may be, and for all we know, who knows what else is going on in her personal life that would make it reasonable that her living expenses would require a much higher, settlement, whatever she was earning. Okay, go ahead.
Good. Okay. I'm just taking a look at some of the questions. It looks like we've got some additional questions.
Yeah, I've been reading them as we go through. So for example, Larry, what if Larry has her, therefore no, and that's really the point of puffery versus misrepresentation. When puffery is I think you said it most eloquently, Bob, where you had said that it's something that is when the attorney has factual information that is essentially discoverable, and you make a statement to the other side, and you add rely on, then it's no longer.
There's a couple, thanks, Mary Grace. There's a couple questions here from Malcolm about what if Larry Lawyer has pay stubs, carries pay stubs, and knows what she earns? Well, then if he's going to represent something different, then it seems like he has to make peace with the ethics opinions that we talked about earlier about a material fact that's of the type that would normally be relied on or expected to be relied on by other people. And Malcolm also raises the question, what if Larry gives a higher number simply because he knows his contingency fee will be higher? And that seems like we've already talked around that or addressed that, which is the attorney who's, regardless of the motivation, if it's to benefit the client or himself, it states a material fact likely to be relied on. It's not an expression of opinion, runs afoul of these provisions that we've been talking about. So let's talk about this one. I think this is a good one. This is a common one here. Oh, go ahead, Mary Grace. Mary Grace, you're
no, I was going to say that
when a lawyer, you're a little bit garbled in the at least for me, it sounds like there's a little bit of trouble in the transmission. So why don't you talk a bit more and let's see if I'm getting a better, more clear signal. You may, and it looks like you might be frozen. You may need to log out and try logging back in. Anne, are you there? Am I the only one who's having some transmission problems?
Let's see. I'm here.
Yeah. Are you able to hear Mary Grace?
I can, not now.
Not now?
No.
Her screen is frozen on my screen.
Yeah, it is.
Okay. Mary Grace, why don't you, would the thing to do, Ann, it would be to have her log out and then log back
Yeah.
in? Can you
Mary
pop
Grace,
in
go
there?
ahead and pop out and pop back in. There you go.
Okay, there we go. Let's bring her
Okay.
in. So while she's gone, I'll go ahead with this hypothetical 7, then we'll have her catch up when she gets back
Okay.
in. So at the mediation, defense counsel Lucas Lawyer states that Daryl defendant intends to file for bankruptcy if Daryl does not get a defense verdict. Well, we've all heard that. We've all been there. In fact, 2 weeks prior to the mediation, Daryl, in fact, consulted with a bankruptcy lawyer and was advised that Daryl does not qualify for bankruptcy protection. And you can actually have those situations. I mean, if you can only file bankruptcy every so often, and you might be within the 7 years or whatever the time frame is and not be able to file again, and was advised that Daryl does not qualify for bankruptcy protection and could not receive a discharge of any judgment entered against him. And again, if you're doing a chapter 7, you have to meet the means test, and you might be in a 13. And anyway, there's a number of issues that go in. It's not just a simple, I'm going to file bankruptcy and get a discharge. Daryl has informed Lucas Lawyer of the results of his consultation with bankruptcy counsel and that Daryl does not intend to file for bankruptcy. Okay, so that's the fact pattern as it's set up. And Mary Grace, I see you're back in, but you're frozen again. I'm not able to hear anything, so you might have to, if you have another computer or a different network that you might be able to use. Yeah, there you go. So here's the question. Is defense counsel's statement that the defendant will file a petition in bankruptcy ethically permissible under these circumstances as mere puffery? Okay, so I mean, that's a really interesting question because maybe he would file, and I mean, you can file. I mean, you don't have to get permission to file bankruptcy. You can file bankruptcy. You just hit the keys and you file electronically and it's done. So I mean, is this a misstatement here? He says Daryl's going to file bankruptcy. Well, technically he could, regardless of whether or not he's eligible. Now you're going to be filing a proceeding that is maybe not legally permissible, and there could be potentially ethical issues with that. So it's maybe not a really good idea to do it if you're not eligible. And so you're trying to figure out, well, can the attorney, Lucas Lawyer, can he split the hairs to still be ethically making these representations, even if Daryl does not qualify and has communicated that fact to Lucas Lawyer? So here's the authority. Defendant's lawyer knows that defendant does not intend to file for bankruptcy and that defendant is not legally eligible to file for bankruptcy, meaning really he could file, but it would not be proper. A statement by defendant's lawyer that expresses or implies that defendant's financial condition is such that he is in fact eligible to file for bankruptcy is therefore a false representation of fact. The conclusion may be different if the defendant's lawyer does not know whether or not his client intends to file for bankruptcy or whether his client is legally eligible to obtain a discharge. So Mary Grace, I'll catch up really quick. We just did hypothetical number 7 about at mediation. Someone says, well, if we don't reach a deal here, then if it goes against me, I'm going to file bankruptcy. So you take that into account on your settlement discussions. And the question is, if the client has found out in advance that he's not eligible for a bankruptcy discharge, he's just flat out not eligible, can the attorney ethically make a representation in the mediation that his client's going to file bankruptcy, and we just came up with this this ethics opinion that says that's a problem if he knows the fact. Yeah.
Yeah, absolutely, that's a problem, because again, it goes back to that what we've been kind of beating everyone over the head with, is that concept of misrepresentation. You absolutely don't want to misrepresent that information, especially if opposing parties may rely upon that in their decision making to either accept or decline a settlement offer.
Okay. So here's a question. Is the answer different that if the client had not expressly consulted bankruptcy counsel? Is the answer different if the client at this point is only considering filing a petition in bankruptcy? Really, I mean, if the attorney knows that the client, what's your thoughts on this?
I think it's part of it is going to be dependent upon, that first part of the answer, which is, whether or not the lawyer, again, a lawyer cannot knowingly share a misrepresentation to, anyone. And so the emphasis here is going to be knowingly. If the lawyer knew that this was going to happen, that's one thing. If the lawyer maybe had reasonable belief, then, let's assume that the client said, well, what if I file for bankruptcy? Like, they just kind of throw it out there as a hypothetical. Maybe the lawyer doesn't know or believe it, for that matter.
Well, let's go to this question that kind of addresses that. Is the answer different if the client is eligible for a Chapter 7 discharge, but is absolutely dead set against filing a petition of bankruptcy and has let the lawyer know that? So in other words, the lawyer knows that the client is eligible, but the client just says, I'm just not going to do it. So where does that come down? What are your thoughts on that?
I think that goes also back to, in representation, there is a division between what the lawyer can do. And I want to pull up the rule real quickly, because when it comes to scope of representation and where the lawyer has authority, that really is, I think, where this kind of hits, is the lawyer has the right to make certain decisions as it relates to the broader representation. So, the lawyer makes the legal decisions, whereas the client, you present this information and the client then can decide as to their broader goals. So lawyer thinks about strategy and how they're going to incorporate the facts and then carry out the strategy, whereas the client is thinking about the goals. Here, the client's goals, yes, may be to settle this for as little as possible, but they've clearly said we're dead set against this. So to share that information otherwise, I think that was really where there's that tension between the lawyer's responsibilities to the client and, responsible role within the broader representation comes into tension with the client's goals.
Okay.
Does that make sense?
I think so, and it's like it's splitting a pretty fine hair, because the client is eligible, and yet the client's not going to do it. So is the lawyer justified in saying, well, my client could file bankruptcy, if we don't get a resolution? Well, she could. That's a true statement. If you understand that's to be taken, meaning that your client may well do it, does that cross the threshold of misleading somebody, just by artful phrasing things? Those are interesting and difficult questions.
I think it's an interesting question because, what if the client is dead set against it and they don't want it shared for other reasons, because even though this is supposedly confidential, let's just be honest, some of this information manages to get seeped out. I know it's supposed to be confidential, but, and let's just assume that for that client, it's a corporation and they don't want anyone else knowing that they have this eligibility for bankruptcy, at least at this point. And so they have other additional reasons. And that goes back to goals, why, either they're not going to file or why they may not want that information shared at this point.
Well, those are some interesting points. I mean, I assume at the outset, and I don't really practice bankruptcy law, but my understanding is anybody can file. It's whether or not you meet the criteria, so whether or not your bankruptcy petition is going to be dismissed.
Right. But I think that again, as an attorney, you have to balance clients' goals and interest versus your litigation practice and style. So I think they're being dead set is one thing, but as a lawyer, you might want to understand, why are they dead set? And not only why are they dead set, but are they, you can say, well, okay, that's fine that you're dead set against filing the petition, but this is an excellent negotiation strategy for you. I think we should share it, and then find out why they might be, do they want this shared or not?
Okay, I think that's fair. Yeah, I think you need to bring your
You
client.
know,
Okay,
I think you really have to scratch that, like get past that initial, like, I'm dead set against it. Well, I'm just using it as a negotiation strategy. Then you need to find out, why are they dead set against it? And are they dead set against us using it as a negotiation strategy?
okay, that's fair, sir. Here's the next hypothetical 8. The matter does not resolve at the mediation, but the parties agree to participate in a follow-up mediation 1 month later, pending the exchange of additional information regarding Carrie's medical expenses and future earnings claim. In particular, Larry agrees to provide additional information showing Carrie's efforts to obtain other employment in mitigation of her damages and the result of those efforts. During that month, Larry learns that Carrie has accepted an offer of employment and that Carrie's starting salary will be $75,000. Recognizing that accepting this position may negatively impact her future earnings claim, Carrie instructs Larry not to mention Carrie's new employment at the upcoming mediation and not to include any information concerning her efforts to obtain employment with this employer in the exchange of additional documents with the defendant. At the mediation, Larry makes a settlement demand that lists lost future earnings as a component of Carrie's damages and attributes a specific dollar amount to that component. So this fact pattern actually comes out of the ethics opinion on the State Bar website. So question, at the second mediation, can Larry properly include future wage loss as a part of Carrie's damages claims without taking into Carrie's new employment as $75,000 per year? And here's the answer from the State Bar ethics opinion. This
And
example.
so
Go ahead.
you're looking at, one, where the failure to disclose the new employment, and then 2, the plaintiff's instruction not to disclose. So those are that's the tension. And so with the with the underlying fact that there is new employment, it is assumed that the plaintiff would not be entitled to future loss of earnings for, because she had found a new job. That impacts the settlement itself. And then such that including in the list of the plaintiff's damages, the separate component for future loss of earnings is an implicit misrepresentation. And that's where the problem lies, is that, not sharing this information because it was a key issue as it, for the settlement. Once she has a job, you're not just negotiating wages lost, but you're negotiating for, future wages. And if she has a job, then she hasn't lost any future wages at that point. And not sharing that information essentially isn't fair to the other side, and it is a misrepresentation of fact.
And that's exactly where the State Bar comes down on this and the ethics opinion. The example raises 2 issues: the failure to disclose the new employment and plaintiff's instruction to attorney to not disclose the information. First, as to the underlying fact of employment itself, it is assumed that plaintiff would not be entitled to lost future earnings if plaintiff found a new job. As such, including in the list, just by the mere fact of including the list, so including in the list of plaintiff's damages a separate component for lost future earnings, is an implicit misrepresentation that plaintiff has not yet found a job. So even if there's not an express statement that plaintiff hasn't found a new job yet, it's done by implication, by including those numbers. This is particularly true because plaintiff agreed to show documentation of her job search efforts to establish her mitigation efforts, but did not include any documentation showing that she had in fact been hired. So it's like a half truth. Maybe you've lost this, but the part that's left out on that half truth is really the operative part. It's the key part, which is you've got a new job, you're not going to have this job loss. Listing such damages then constitutes an impermissible misrepresentation, as discussed in Schofield versus State Bar, where an attorney who combines special damages resulting from two different auto accidents and separate claims against each defendant disciplined for making affirmative misrepresentations with the intent to deceive. Or Pickering versus State Bar, where an attorney who alleged claim for loss of consortium knowing the plaintiff was not married and that her significant other was out of town during the relevant time period violated the Business and Professions Code. So it's you know, once you make those factual representations and you know they're not true, it is materially and just qualitatively different than a statement of opinion or the kind of things that people are not reasonably expected to rely on. And these are just more illustrations of that. Any further comments on that? Right, Grace?
I would also encourage everyone who's practicing in mediation as a lawyer, not as the mediator themselves, but as a lawyer, to consider, look at Rule 3.4, which is fairness to opposing parties and counsel. And this outlines very clearly, and I apologize, my dog is stuck in my room right now with me and he's not happy. It gives you, it really outlines what a lawyer can and cannot do as it relates to negotiation and sharing information with opposing party. You know, that rule explains, you know, everything from how to share information, what you can withhold, what you shouldn't withhold. And so I encourage you to look at 3.4, and because of these types of material disclosures that are needed and can impact, you know, the broader representation.
All right. Here's the follow-on point on this hypothetical. Question: what are Larry's ethical obligations in connection with Carrie's instruction that he not disclose this information? Okay, so it's this unenviable position where the attorney knows the truth and the client is specifically instructing the client. I mean, the client is specifically instructing the attorney, don't share this. So, I mean, when an attorney gets a client instruction like that, can the attorney just go ahead and say, well, they need to know it, so I'm gonna run over the top of this client instruction or disregard it? It's really a
Right.
tough question.
I'm pulling up really quickly the cross-reference table. So the rule is hold on a second, I'm just pulling up something, 3-100. So I can give you the current rule, and the reason why it has the old rule is because of the fact that we quoted this from the
Right.
2015 opinion. So
Right.
I wanted to give you all the current rule. So with regard to 3-100, the new rule is actually 1.6, which is confidential information of a client. And then the other rule is 3- let me pull it up, 700, which is it would be 1.16. And so when an attorney and a client, you know, we're going back to client goals versus attorney's duties. This is really where that, you know, tension is. You have a conflict of interest at that point. If your client is telling you to do something that is essentially falsifying information to opposing party, they're asking you to do something that is unethical and illegal. So at that point, an attorney really has to, one, explain to the client what they're doing and why you cannot do it. And then advise them that you're not going to do this, it is unethical. At that point, try to bring them back to explaining why you have to share this information. Again, if they are insistent on taking this path, at that point, you may have to withdraw because you actually have a conflict of interest that was what I call an incurable conflict of interest. They're asking you to do something that violates your ethical duty, not just to this particular representation, but as it relates to your license itself. Looks like we have a question. Has a state bar taken a position on whether it will consider anything communicated in mediation in connection with a state bar complaint? I'm going to be honest with you, I have not seen anything outside of, you know, either my practice or outside of what I've, what is in the public record. And there's very little that shows up within mediation. That's why when we started talking about, the disclosure rule for mediators and for attorneys in mediation, as it relates to the confidentiality of mediation, I cannot tell you whether or not any lawyer has been investigated, because those are highly confidential and the state bar doesn't share that information. Nor have I seen any state bar discipline that has specifically arisen out of, these types of moments. What we have seen is kind of like what we've quoted here, which is sometimes, and I apologize, my dog really wants to get out. Such as when a lawyer has actually been disciplined due to how they negotiated. So to say, that it was specific to mediation, I am not 100% sure. As of right now, I haven't seen any cases specifically dealing with mediation in my own practice. It's not saying that there aren't cases or investigations that are out there. It just means that in the broader case law, there isn't much out there on, as it relates specifically to mediation. I can double check though, if you would like, and get back to you on that.
Okay, perfect. Thank you, Mary Grace. Okay, perfect. So this.
We have about 8 minutes left.
Yes. Okay. This slide here, it highlights the very difficult duties that that we labor under as attorneys when we're providing legal services. And we have these very high duties to these clients, but there's a supervening duty, which is the statutes and the rules of professional conduct. And so when there's a conflict between those two, the rules of conduct always win. I mean, they always win. And so if you cannot persuade your client to do the right thing and bring their instruction to you within the ambit of what's allowable under the rules, then as shown out by this slide, these rules require withdrawal if you just can't get there. And we all kind of know that as attorneys, but it also happens in a negotiation or potentially in a mediation setting. So here's the follow-on.
And
the attorney should first oh, go ahead, Mary Grace.
I think that the other tension that I don't always think that lawyers are good at understanding is these types of subtleties where, you're trying to do well by your attorney, but I think we sometimes don't always, and I see this in my own practice where lawyers don't always see when the tension arises between their duty as it relates to their license and their duty of honesty and candor, and how that can actually be, directly in conflict with what their clients are trying to do. Lawyers aren't always good at, picking up on that particular issue.
Okay. All right, good. Let's go to the next hypothetical. It's hypothetical 9. At mediation, Larry tells the defense that the defense offer is unacceptable because the offer amount leaves his client with too little after Larry's attorney's fees are paid. Defense counsel balks at this claim. Larry discloses that his fees will be 55% of the total recovery. Defense counsel doesn't believe him. I mean, who defense counsel says, who takes a 55% contingency fee? No, nobody does that. Larry has with him a copy of his fee agreement with Carrie client. This is not out of one of the state bar ethics opinions, but it's cobbled together in facts. Question, can Larry ethically disclose to defense counsel his percentage of the recovery without first getting permission to do so from Carrie client? So what's your thoughts on that, Mary Grace?
Again, it goes back, first, a lot of the attorney-client agreement is actually a confidential communication between the attorney and the client. So sharing that information may actually be a disclosure of attorney-client privilege. So, that's where you want to start, is that particular issue. It I've even done this before the state bar, where they've asked, can we have the engagement letter? And if my clients, either current client or former client, didn't file the state bar complaint, they never waived attorney-client privilege as it related to that engagement letter. So I tell the state bar to go pound sand on that. And so it is considered, you never share the attorney-client agreement, period. And I just think it's really bad lawyering to share what you're going to walk away with, because that also looks, I don't think it paints a very nice picture of the attorney as, to the defense side, sharing that information.
Okay, so we've talked about it's in fact a confidential document under Business and Professions Code 6149, deemed a confidential communication. All right.
I mean, I think it maybe the client agrees to it, but I don't see why it would be wise to even ask the client to share, to allow you to do that.
So
I do know that sometimes when attorneys' fees are being paid out, there's sometimes an issue about questions, so let's just assume that opposing side is having to pay attorneys' fees. Maybe there's a question about what the attorney's walking away with. Even then, opposing side is only allowed to have access to what the attorney actually did, and limited information as it relates to their billable hours. But that's only because opposing side is having to pay out, the lawyer's billable hours, but they're still not allowed to have access to the engagement letter itself.
Okay. Hypothetical 10, after several hours of hard negotiations at mediation, Carrie's personal injury case still has not settled. However, the parties are close. Defense counsel meets directly with Larry out in the hall, tells him that he just can't get any more money from the plaintiff, and says the case will settle if Larry will just discount his fees by $20,000. There's no written offer of settlement. There's a question. Is Larry obligated to communicate this oral offer to his client? Okay, yes. So the offer is to the client. So, okay, the answer is yes, and here it is. A lawyer shall promptly communicate to the lawyer's client all amounts, terms, and conditions of any written offer or settlement made to the client. And then here's the next part. An oral offer settlement made to the client in a civil matter must also be communicated if it's a significant development under Rule 1.4. That's in the official comments.
And again, this is a new rule. This rule didn't exist in the old rules. And pay attention when I read this and I do my own analysis for clients is, it says shall and it says promptly. And I think that is an operative word. It isn't a reasonableness standard. It is a prompt standard. Prompt for state bar purposes, and I would even say possibly malpractice purposes, is something within like 24 hours to a week, depending on what else is going on in the attorney's life. I mean, if you're at the mediation and this happens, then it seems silly to wait, and your client is there, to wait 24 hours before you tell them. You'd want to tell them right then and there. But if it's one of those where there's an emailing back and forth, for example, and you receive an email explaining this to you, then maybe prompt is 24 to 48 hours. But usually when I see in the rules concepts of prompt, I always encourage my clients that prompt really means 48 hours, 24 hours. Sometimes prompt can mean a week, depending on if there was additional issues going on. With regard to this particular issue, I would say though that the lawyer, let's just assume they receive this information and they want to do additional negotiations. I don't believe under this rule, the lawyer can withhold this information and try to negotiate further, because the client may be at that point, depending on whatever's going on in their personal lives, be ready to, you know, walk away from that $20,000 because they just want that settlement at that, because they've been litigating this and they've been negotiating this for, say, 4 years. They just want that money at that point.
Well, the way that this fact pattern was presented is the settlement proposal was made to the lawyer for them to take the hit on the fees. But realistically, when the lawyer communicates to the client, I mean, it's really a proposal that the client take less and then figure things out with the lawyer. And so what are your thoughts on that? When the lawyer goes back in and says to the client they want $20,000 less, is the lawyer obligated to add in there and they want it to come out of my fee, or is it just a $20,000 reduction in what you're willing to take?
I think they have to disclose the whole piece, because it does impact the client's ability to make a decision whether or not to settle, you know, to accept the settlement. You know, if they're not disclosing that fact that it's going to come out of my fees, the client might be thinking, well, I'm going to walk away with, you know, whatever their fee division is. Let's just assume the fee, we're going to keep with that clean fee division of $100,000, and we're going with 40,000. We're not going to worry about the 55 because I can't do the math that high. But, you know, it would mean that it would be a division of $80,000. So maybe they're like, ah, well, you know, we both get a little bit less. But if it's something like, I still get what I originally wanted and you have to get less, you know, the client, depending on the client, some clients might be, you know, because I've met these types of clients where they really want their attorney to get their full value, and other clients maybe not so much.
So let's finish up on this question. I think we're right at our time here. Does this offer create a conflict of interest between Larry and his client? And if so, what are Larry's ethical duties with respect to such conflict?
You know, I think it depends. Like, that's always, I think this one's a tough one, to be honest with you, because it's at the end of the negotiation. It's not like Larry is where our other fact patterns where Larry was making decisions about the settlement purely for his own pecuniary gain. In this particular situation, right now, he has to take less money. If it were to be something like, let's just assume there's an additional fact where the client then says, hey, Larry, what do you think? Should I do it? Because maybe they're on the fence. Maybe they really like Larry and they want Larry to get his $20,000. So they're not really sure if they should do this. Then I think that potentially creates the conflict of interest, right? At that point, you would say, well, these are your options. Go talk with someone else before you make this final decision.
Exactly. Very good. Well,
You know, that's a tough one. I think that's really hard.
very tough. Agreed. This brings us to the end of our program, end of our time. And thank you very much for joining us. Any final comments that you have, Mary Grace, for the end of our program today?
You know, I think what we were covering really hits on the gray areas of law, where there's certain parts of this, it's very clear in terms of what you should and shouldn't do. But there's other parts, and, you know, a lot of the questions hit on this is like the difference between puffery versus withholding facts, and where does that, you know, line really fall. And and so if I sound a bit waffly, it's more so because of the fact that it is very fact intensive. And so when I have a client, you know, I can have two clients with relatively similar matters, but it really takes that deeper dive, that looking at and sifting through the facts. And that's the difficulty with ethics, is that it's not a very clear cut analysis for anything that we do. And so it's easy, and what we're presenting for Bob and I is truly the gray areas of this practice and how we can step in it.
Absolutely agreed. Yeah, yeah. Very interesting questions, very tough ones. We all have to grapple with them. So thanks very much, Mary Grace and Ann, and that wraps up our program.
Thank you, everybody. Thank you,
Please,
Mary
and
Grace.
apologies for
That
my
was great.
technology issues. My Wi-Fi froze. I really do apologize.
No worries. I think it's in the air today. You're not the first. Thanks very much, everybody. Have a great rest of the week.
All right. Thanks, Ann.